Hi and welcome to History's Edge. Today, we're diving into the story of justice in ancient Rome, a story of law, power, and punishment, written not just in scrolls, but carved into bronze and stone. In the year 451 BCE, the Roman Republic took its first step toward a legal system that could apply to every citizen. Under pressure from the people, Rome's leaders created the 12 Tables, laws engraved on bronze and displayed in the Forum, where anyone could read them. These laws were simple, direct, and often brutal. They said, for example, that if you broke another man's bone, he had the right to break yours in return. Fairness, in Roman terms, meant balance, not mercy. These weren't just laws, they were tools. Tools of order, tools of control, and often tools of fear. Across centuries, Roman justice evolved from tribal tradition into a complex web of courts, judges, trials, and punishments. And behind the system stood emperors, magistrates, and governors who often shaped the rules to serve themselves. In this documentary, we'll walk through real Roman trials, examine newly discovered documents, and explore how justice was delivered. Sometimes in courtrooms, sometimes in arenas. We'll explain terms like iudex and lex talionis, and show how even the most ordinary citizens lived under a legal system that mixed reason with brutality. Everything you hear is grounded in double-checked historical research, supported by archaeological findings, and sourced from ancient texts and modern scholarship. If you enjoy accurate, immersive storytelling about the ancient world and want to support more documentaries like this, we'd love if you subscribed. Let's begin. Chapter 1. The Law is Born. Long before emperors ruled from marble palaces, and before Rome was a global power, it was a city in conflict. In the 5th century BCE, Rome was still young, and its people were divided. The patricians, a wealthy elite, controlled nearly everything. They held the offices, ran the courts, and interpreted the laws in private. The plebeians, Rome's common citizens, had little say, and even less protection. The laws at this time were unwritten. Justice was whatever a patrician magistrate said it was. Punishments could be harsh and inconsistent, and the people were growing restless. That unrest led to a turning point. In 451 BCE, under immense pressure from the plebeians, the Roman state agreed to write down its laws for the first time. A group of officials, called the decemviri, were appointed to draft the code. The result was a document known as the 12 Tables, Lex Duodecim Tabularum. These laws were engraved on bronze tablets and placed in the Roman Forum where anyone could see them. They were short, blunt, and often harsh, but their power was in their visibility. For the first time, a Roman citizen could know their rights and obligations without relying on a patrician's word. The content of the 12 Tables gives us a glimpse into early Roman values. Table 1 described how to summon someone to court. Table 2 laid out rules for trials, including the use of judges and time limits. Table 4 dealt with the rights of fathers over their families, including the chilling right to kill a deformed newborn. Table 8 listed punishments for crimes like theft or slander, including public whipping, fines, and, in some cases, death. To modern ears, these rules might sound brutal, but to ancient Romans, they were progress. These laws created predictability in a society that had once operated on privilege and guesswork, and they applied, at least in theory, to both rich and poor. One law stated that if a person owed a debt and failed to pay, they could be bound in chains for up to 60 days, paraded publicly, and eventually sold into slavery. Harsh but structured. The law was not kind, but it was consistent. The 12 Tables became the foundation for all Roman law that followed. Even centuries later, students in Roman schools were made to memorize them line by line. they were more than a legal code. They were part of Roman identity. But the 12 tables were not perfect. They still favoured the elite, and the poor remained vulnerable. And even as the laws became public, those in power found new ways to bend them. Still, the idea that law should be written, visible, and accessible was revolutionary. It set Rome apart from many other ancient societies where justice remained in the hands of priests or kings. In Rome, justice became a public matter. This was only the beginning. As the Republic grew, so did its legal system. Courts became more formal, legal language evolved, and the use of professional advocates emerged. And at every stage, Roman law continued to walk a thin line between fairness and control. Chapter 2: Magistrates, Praetors, and the Machinery of Justice. As Rome transitioned from monarchy to republic, it needed new tools to manage its growing population and expanding territory. One of the most important tools was the magistrate, a Roman official empowered to enforce the law, judge disputes, and maintain order. In the early republic, the highest magistrates were the consuls, 2 elected men who shared executive power. They commanded armies, proposed laws, and oversaw the courts. But as Rome grew more complex, new roles were created to divide the weight of responsibility. One of the most important was the praetor. The praetor was introduced in 367 BCE. His main job was to oversee civil law, particularly disputes between Roman citizens. In time, more praetors were added, one to handle cases involving foreigners, another for provincial matters. These officials didn't just interpret the law, they helped develop it. Each praetor issued an annual statement, known as an edict, outlining how he planned to handle legal questions during his term. Over time, these edicts shaped Roman legal thinking. But magistrates were not judges in the modern sense. They didn't always deliver final verdicts. Instead, they acted more like administrators. They determined whether a case should go to trial, and then assigned it to a iudex, or private citizen acting as a judge. This system meant that ordinary Roman citizens played a key role in justice, at least on paper. Magistrates also controlled imperium, the right to command, both in military and judicial matters. This authority was symbolized by lictors, bodyguards who walked ahead of a magistrate carrying facies, bundles of rods with an axe in the center. These were not just ceremonial. They reminded everyone that the magistrate could punish, even execute if necessary. Below the praetors were other officials who kept the legal engine running. Aediles managed the streets and markets, enforced building codes, and oversaw public festivals. Censors maintained the census, supervised public morals, and could remove senators from office for misconduct. Quaestors handled financial matters and court records. All magistrates were elected annually by Roman citizens, though in practice, power circulated among the elite. Wealthy families dominated the political offices, and access to justice often depended on connections. Still, the system had its strengths. It was structured, visible, and ritualized. Trials were held in public. Decisions could be appealed to higher officials or even to the assemblies of the people. The presence of multiple magistrates, each with specific duties, prevented the concentration of too much power in one pair of hands, at least in theory. Over time, the Republic's legal machinery became more refined, but also more political. Trials were often used to damage rivals or gain favor with the crowd. A successful legal career could launch a man into higher office. For many, justice was a path to power. The machinery of Roman justice was not built for speed, it was built for order. From the moment a dispute arose, it passed through a careful process, a summons, a hearing before a magistrate, assignment to a judge, and a trial conducted under strict legal procedures. This process helped Rome govern not just a city, but eventually an empire. Yet, as we'll see, a system so reliant on reputation, wealth, and status was vulnerable. And in the provinces, far from Rome's watchful eye, the machinery often broke down. In the next chapter, we follow a Roman citizen through the full trial process, from summons to verdict. We step into the forum, where justice was not only served, but seen. Chapter 3. Trial by Forum. In the heart of ancient Rome, justice was not hidden behind closed doors, it was performed. Roman trials took place in public, often in the forum, surrounded by crowds, noise, and the ever-watchful eyes of the city's citizens. It wasn't just a process, it was a spectacle. The structure of a Roman trial was very different from what we might expect today. There were no lawyers in the modern sense, no robes or gavels, and no single judge overseeing the courtroom. Instead, the process was split in two parts. First, a magistrate, usually a praetor, decided if the case was valid and which legal formula applied. Then, the case was handed to an iudex, a private citizen selected to act as a judge. Sometimes a panel of iudices was chosen for more complex cases. These iudices were not legal professionals. They were often upper-class Romans, chosen for their reputation rather than legal training. Still, their decisions carried full legal weight. And once the trial began, it was their judgment that decided the outcome. Trials were conducted with both sides presenting their arguments aloud. There was no written record and no transcript. Everything relied on memory, persuasion, and performance. Roman oratory was a powerful weapon, and the best speakers could sway not only the iudex, but the crowd that gathered to listen. One of the most famous figures in Roman legal history was Marcus Tullius Cicero. As an advocate, Cicero mastered the courtroom. His speeches were rich with rhetoric, sarcasm, emotional appeals, and sharp logic. In defending Sextus Roscius, who had been accused of murdering his own father, Cicero didn't just argue law. He painted a vivid picture of conspiracy, political betrayal, and injustice. And he won. In many cases, especially during the late Republic, trials became tools of politics. Accusing a rival of corruption could damage their career. Defending a popular figure could boost your own. Wealthy Romans would often hire a skilled orator to represent them, not because it was required, but because it gave them an edge in performance. The public setting of the forum made every trial a kind of theatre. Onlookers could cheer, murmur, or whisper their opinions as the case unfolded. Reputation mattered. A skilled speaker who humiliated his opponent in front of the crowd gained prestige. A poor performance, or a visibly nervous defendant, could shift public opinion before the verdict was even reached. Criminal charges, such as bribery, embezzlement, or even murder, could carry serious consequences. Fines, exile, or in extreme cases, death. But many disputes were civil. Arguments over land, debts, contracts, or family inheritance. These could stretch on for weeks and were often resolved through negotiation, especially when both parties were powerful. It's important to remember that Roman law, even at its most sophisticated, favoured the elite. The poor had limited access to skilled defenders. Trials moved faster for those with influence, and while the forum was public, power still controlled the stage. But despite its flaws, the Roman trial system was remarkably advanced for its time. It involved rules of evidence, examination of witnesses, and structured legal arguments. It placed the burden of proof on the accuser, and, in theory, it gave every citizen the right to defend themselves. Justice in ancient Rome may have been imperfect, but it was visible. Every citizen could witness it unfold, and every trial left behind not only a verdict, but a story. In the next chapter, we'll leave the forum behind and travel to the provinces, where Roman law was often twisted, ignored, or exploited by those in power, far from the eyes of the capital. Chapter 4. Corruption in the Provinces. The power of Roman law did not end at the city walls. As the Republic expanded and later transformed into an empire, Rome exported its legal system across continents. From Hispania in the west to Syria in the east, governors and magistrates were sent out to uphold Roman order. But far from the scrutiny of the capital, justice often became a tool of convenience. In the provinces, law was enforced by governors, men appointed by the Senate or the emperor. These governors held imperium, meaning they had near total authority over military, civil, and legal matters within their region. But with power came opportunity, and many used the legal system to enrich themselves. A governor could preside over trials, appoint judges, and interpret laws with little oversight. In many cases, the local population did not speak Latin, and Roman law seemed alien to them. That gap in understanding made it easy for officials to manipulate outcomes, especially in disputes involving land, taxes, or commerce. Local elites were often forced into compliance with legal rulings they neither understood nor agreed with, simply because resistance meant retaliation. One of the most revealing pieces of evidence comes from a recently analysed papyrus found in the region of Roman Judea. This document, written around the 2nd century CE, records a legal transaction involving a Roman official who falsified a court ruling in exchange for payment. The text shows the use of forged seals and signatures, and even outlines how the official coached one party to present false evidence. It is a rare and chilling glimpse into how justice could be sold. This wasn't an isolated case. Roman historian Tacitus wrote of governors who plundered entire cities, using trials as formal excuses for extortion. Pliny the Younger, in his letters, often described efforts to clean up such abuses. And Cicero himself, while serving as governor in Cilicia, famously prosecuted another governor, Gaius Verus, for rampant corruption in Sicily. Verus had taxed grain beyond legal limits, seized private property, and punished locals without trial. He even stole artwork from temples under the pretense of legal confiscation. Cicero's prosecution of him became a model for exposing abuse of power and a warning to future officials, though in practice, corruption remained widespread. In many cases, justice depended not on the law, but on the character of the man in charge. A cruel governor could ruin entire communities, while a fair one might protect them. But fairness was never guaranteed, and even honest governors worked within a system that often lacked checks and balances. To the Roman state, the provinces were valuable primarily for their output. Grain, taxes, metals, and soldiers flowed from the edges of the empire towards the capital. Law was meant to keep this machine running. If corruption helped keep order, it was often overlooked. The well-being of local populations came second to stability. For many Roman officials, a provincial posting was a short-term opportunity. They knew they had limited time to accumulate wealth before returning to Rome. Trials were often rushed, biased, or entirely fabricated. Locals who lacked Roman citizenship had few options for appeal, and even citizens who lived far from Rome found it difficult to challenge a verdict handed down by an appointed magistrate. And yet, Roman law still held prestige. Many provincial elites adopted Roman legal practices, learned Latin, and even trained their sons in Roman law to gain favour. Local cities that were granted Roman-style courts saw their status rise. In some cases, a good governor could genuinely improve the rule of law. He might mediate disputes fairly, encourage education, and invest in civic life. But those men were the exception, not the norm. The provinces reveal a contradiction at the heart of Roman justice. It was a system that claimed universality, but in reality bent to the convenience of the powerful. Rome promised law and order, but delivered it unevenly. Where law failed, fear stepped in, and where truth was inconvenient, it was rewritten. The papyrus from Judea is now kept in a museum. Its faded lines, written in careful ink on a fragile surface, expose something that was once meant to stay hidden: how legal language could be turned into a tool for fraud, and how, in the vast and varied empire of Rome, even justice could be bought with silver. In the next chapter, we'll explore another side of the Roman legal world, the blood-stained stages of the arena, where punishments became public performances, and where justice was served not in silence, but with spectacle. Chapter 5. Justice as Spectacle. In Rome, justice was not always handed down in quiet courtrooms. Sometimes it was shouted in front of thousands. Sometimes it was written in blood. Public punishments were a powerful part of Roman law. They weren't just a consequence, they were a message. A thief whipped in the forum warned others to obey. A slave crucified outside the city reminded everyone of their place. The state didn't just punish wrongdoers, it made an example of them. The most infamous stage for this kind of justice was the amphitheatre. While we often associate the arena with gladiators and sport, it was also used to carry out legal sentences. Criminals, prisoners of war, and slaves condemned to death could be sent into the arena to die in brutal fashion. These executions weren't always private or solemn. They were built into the entertainment schedule. The Romans even had a word for it: damnatio ad bestias, condemnation to the beasts. In these events, the condemned would face lions, leopards, or bears. Sometimes they were armed, often they weren't. The crowd would cheer or jeer, and when the animal struck, the lesson was clear: Rome had no mercy for enemies of order. These executions often followed a legal process. A person found guilty of serious crimes, like treason, desertion, or rebellion, could be sentenced by a magistrate or governor to die in the arena. But once the sentence was handed down, the state stepped back and the people stepped in. The punishment became a public ritual. Evidence for these spectacles isn't just in Roman texts. Archaeologists have uncovered the skeletal remains of men in Roman Britain with claw marks on their bones, consistent with large cats. One find near modern-day York suggests that a young man may have died in the arena, his body discarded after a staged execution. His vertebrae show clean cuts, as if from a sword, while his ribs carry marks of animal bites. This was not battlefield trauma. This was punishment on display. For the audience, these scenes blurred the line between justice and performance. Criminals were dressed in costumes to resemble mythological figures, like Prometheus, chained and devoured by an eagle, turning executions into theatre. It was spectacle with symbolism. The crowd wasn't just watching a death. They were watching the state reinforce its power through carefully staged punishment. In other cases, the condemned were made to fight each other for the crowd's amusement. These were not trained gladiators. They were prisoners, forced into combat with little hope of survival. Roman playwrights even joked about the poor skills of these men, mocking their deaths for the entertainment of the elite. The arena served the empire. It kept the people entertained, reinforced fear, and gave Rome's enemies a final moment of humiliation. And though not every sentence led to the sand, the possibility always loomed. It reminded everyone, citizen or slave, that Roman justice could be swift, public, and absolute. But this was only one side of the system. For every execution in the amphitheatre, there were dozens of quieter punishments: fines, exile, or loss of status. These were handed out with less blood, but sometimes no less cruelty. Roman justice was flexible. It could be methodical, ritualized, and civic, or it could be violent, theatrical, and immediate. Either way, the goal was the same: control. In the next chapter, we return to the halls of power, where emperors used the legal system not just to punish criminals, but to eliminate rivals, silence critics, and protect their rule. Chapter 6: Law and the Emperors. When Augustus took control of Rome in 27 BCEA, the Republic became an empire, and the law began to reflect it. No longer simply a tool for maintaining civic order, Roman justice became an extension of imperial power, and the emperor stood at its center. Augustus was careful in his image. He didn't abolish the Senate or the courts. He presented himself as a restorer of order, not a dictator. But behind the scenes, he controlled appointments, shaped the legal process, and steered outcomes. It was a delicate balance, the appearance of tradition held up by a structure of control. As time passed, later emperors were less subtle. Tiberius, Augustus's successor, used the law to eliminate threats. The crime most often prosecuted during his reign was mastas, or treason. Originally, this law protected the dignity of the Roman state. Under Tiberius, it became a tool for silencing critics. A senator who spoke too freely, a poet who mocked the regime, even a wealthy citizen with too many allies, all could be charged. Conviction meant exile, confiscation of property, or death. By the time of Nero, the legal process had become a performance. Accusers were often rewarded with a portion of the condemned man's estate. Trials became a form of political theatre. A charge of treason didn't have to be proven, only suggested. Even silence could be considered disloyalty. The emperor himself could not be tried, only obeyed. While magistrates and courts still existed, their independence faded. The law no longer stood apart from the ruler. It served him. But emperors didn't just use the law for punishment. They also issued reforms. Augustus passed marriage laws designed to increase birth rates and moral behavior. He granted more legal rights to freed slaves. Claudius introduced reforms to speed up court cases and reduce delays. Even Nero, remembered for his cruelty, passed laws to protect slaves from arbitrary execution. These changes were real and sometimes progressive, but they also reminded everyone that justice came from the top. An emperor's whim could improve the law or destroy it. One of the most notorious examples of legal manipulation came under Domitian. Like Tiberius, he revived treason trials, turning them into a steady purge of senators and rivals. Informants flourished, and trials lost any pretense of fairness. Roman historian Suetonius later wrote that under Domitian, the law itself seemed afraid. Still, the illusion of legality remained. Even the worst emperors used the courts. They understood that justice, even when twisted, carried legitimacy. A public sentence gave the appearance of due process, even when the outcome was predetermined. In provinces, governors mirrored this behavior. Those loyal to the emperor learned quickly that bending the law to imperial will was not just allowed, it was expected, and those who hesitated could find themselves on trial instead. For ordinary Romans, this was a dangerous time. A wrong word, a wrong connection, or even a rumor could lead to a charge. But it wasn't always the emperors who initiated these trials. Sometimes citizens used the system against each other, settling scores through legal accusations. In a world where the law could be weaponized, everyone became vulnerable. And yet, Rome's legal system survived. Even in these dark moments, the structure remained. Trials were held, records were kept, and the idea of justice endured. But it had changed. What had once been a civic tool had become a political instrument. In the next chapter, we'll look beyond the imperial courtrooms and into the lives of those often left out of legal history. the slaves and women of Rome, whose status in the eyes of the law was fragile, shifting, and often unjust. Chapter 7. The Role of Slaves and Women. In the grand architecture of Roman law, not everyone stood on equal ground. The courts and codes that governed the empire were detailed and complex, but their protections were not universal. Two groups stood especially vulnerable: slaves, who were legally considered property, and women, whose legal independence was always limited, no matter their status. Roman slavery was not defined by race, but by legal status. A slave, known as a servus, had no personal rights under the law. They could not own property, enter contracts, or marry in a legal sense. They could be punished, sold, or executed at the discretion of their master. And while some laws protected slaves from excessive cruelty, enforcement was rare. One form of punishment for disobedient slaves was crucifixion. It was brutal, slow, and public. In one case recorded by Roman historians, a slave accidentally dropped and broke a valuable cup during a banquet. His master ordered his immediate execution. No trial, no appeal, just punishment. Yet even within this system, there were paths to freedom. A slave who gained the trust of their master or earned enough money through permitted work could be formally freed in a process called manumission. Once freed, a person became a libertus, a freedman or freedwoman, and gained limited citizenship rights. They could own property, start businesses, and pass on wealth to their children, who would be full Roman citizens. Some freedmen became wealthy and influential. Others remained in the shadow of their former masters, bound by social obligations and legal restrictions. Still, manumission offered a future that many slaves in other ancient cultures never had. The legal position of women was more complicated. In theory, Roman women were citizens. They could own property, inherit wealth, and manage businesses. Some became highly educated and active in cultural life. But under the law, they were almost always placed under the guardianship of a male relative, a father, husband, or legal guardian known as a tutor. This guardian could approve or block contracts, oversee legal matters, and manage inheritance. A woman's ability to act independently in court depended on her status, her wealth, and sometimes her connections. Marriage brought further legal complexity. Roman law recognized different forms of marriage, each with different implications. In manus marriage, a woman passed into the legal authority of her husband. In sine manu marriage, she remained under her father's control. Over time, sine manu became more common, giving elite women more freedom, at least in theory. Divorce was legal and surprisingly common. Either party could initiate it, though in practice, men had greater power to enforce outcomes. A divorced woman could keep property she brought into the marriage, but child custody usually remained with the father. Roman women could appear in court, especially in civil cases involving property or inheritance. But they rarely served as witnesses in criminal trials, and were excluded from voting or holding office. Their voices, when heard, carried less legal weight than those of men. Despite these restrictions, some women found ways to exert legal influence. Wealthy matriarchs used their property and patronage to shape politics. Others wrote wills that strategically directed their fortunes after death. And in rare cases, women even appeared as plaintiffs in high-profile trials, particularly when defending family honor or ancestral estates. But for most Roman women, the law was a framework they lived under, not something they shaped. And for most slaves, it was a system that bound their lives tightly, with little hope of appeal. The Roman legal system was vast and layered. It could be flexible, even progressive, but its foundation rested on hierarchy of class, gender, and status. Justice, as it was written and practiced, was not blind. It saw who you were. and it often judged you for it. In the next chapter, we turn to the core of that judgment, the laws themselves. We'll explore the kinds of crimes Romans faced, how they were punished, and how the empire maintained control through fear, ritual, and consequence. Chapter 8: Crime and Punishment. For the average Roman, the law was most visible not in contracts or senatorial decrees, but in punishment. From the marketplace to the military camp, justice was something you could see, hear, and often fear. Crime was inevitable in a city of 1 million people, and Roman law developed elaborate methods to deal with it, some practical, others terrifying. Rome didn't have a formal police force like we know today. Instead, basic order was maintained by the lictors, who accompanied magistrates and could arrest citizens on command. In the city itself, nighttime safety was the job of the vigils, a kind of fire brigade and night watch combined. They patrolled the streets, stopped thieves, and responded to disturbances. But for the most part, public order depended on citizens reporting crimes and appearing in court to pursue justice themselves. Crimes in Rome were divided into public offences and private wrongs. Public crimes, like treason, bribery, or inciting riots, were seen as threats to the state and carried severe punishments. Private wrongs, such as theft, damage to property, or personal injury, were handled more like lawsuits. The victim, or their family, had to initiate legal action. Minor theft could result in repayment with penalties or corporal punishment, but serious crimes were treated harshly. A man who committed arson might be burned alive. A woman found guilty of poisoning, a common accusation in elite circles, could be buried alive in a sealed chamber, especially if she was a priestess or held public trust. One of the most feared punishments was exile. A Roman citizen convicted of a serious crime could be banished from the city or even from Italy itself. Exile meant loss of status, property, and social ties. For elite Romans, it was often worse than death, a slow erasure from public life. Another common penalty was confiscation. If a man was convicted of corruption or treason, his estate could be seized by the state. In some cases, even his family was barred from inheriting wealth. This wasn't just justice, it was humiliation. Roman punishments were often symbolic. A soldier who deserted his post might be beaten by his entire unit in a ritual called fustuarium, meant to restore discipline through collective action. A traitor might be executed on the Gemonian stairs, a grim public staircase in Rome where the bodies of the condemned were left to rot in view of the crowd. For non-citizens and slaves, the punishments were even more brutal. Crucifixion, forced labour in the mines, or execution by beasts in the arena were all considered acceptable penalties. The law protected citizens. Others were at the mercy of the system. But not all punishments were violent. Fines were common, especially for the wealthy. Losing social rank, known as infamia, was another legal tool. A senator or equestrian who was publicly disgraced could be barred from office, stripped of honours, or prevented from testifying in court. Reputation mattered in Rome, and the law could destroy it with a single verdict. There were also rituals of atonement. In some cases, a convicted man could offer a sacrifice, dedicate wealth to the gods, or undergo public penance to avoid harsher penalties. Religion and law were closely tied. Breaking an oath, defiling a temple, or violating religious boundaries could bring legal consequences as well as spiritual fear. Despite the cruelty of many Roman punishments, the system valued process. Trials followed procedures. Accusers had to present evidence. Witnesses could be called. Appeals were sometimes allowed. And written laws, especially under the empire, became increasingly complex and organized, thanks in part to professional jurists who interpreted the law and guided magistrates. But justice was not evenly applied. Wealth and status influenced outcomes. A poor man might be executed for theft. A rich man might pay a fine and walk free. The system was built to maintain order, not fairness, and it served the needs of a society that prized hierarchy, control, and public example. In the next chapter, we leave the courtroom and the gallows behind and examine the documents, contracts, and written laws that formed the backbone of Roman legal life, and how words, more than weapons, held the empire together. Chapter 9. The Letters of the Law. Rome was a city of laws, but also of documents. Behind the courtrooms and public punishments stood something quieter, something that gave Roman justice its strength. It was not the lictor's rod or the judge's voice. It was the written word. Roman law lived on paper, on parchment, and on wax. It was carved into bronze, scratched onto wood, and inked onto scrolls. The empire's legal system relied not just on rules, but on records. And the Romans were meticulous. From the earliest days of the Republic, laws were published, literally made public. The 12 tables, the foundation of Roman law, were engraved onto bronze tablets and displayed in the Forum. This wasn't just symbolic. It meant the law belonged to the people. If a citizen wanted to know their rights, they could go and read them. As the empire expanded, the need for record-keeping grew. Legal transactions were documented in writing. Wills, contracts, manumission papers, and marriage agreements were all formally recorded. These documents were usually prepared by scribae, trained clerks who worked in temples, courts, and administrative offices. Many of them were slaves or freedmen, but their role was essential. Without them, Rome would have collapsed under the weight of its own bureaucracy. One of the most common writing materials was the wax tablet, a small wooden frame filled with wax that could be inscribed using a pointed stylus. For more permanent records, Romans used papyrus, imported from Egypt. Important laws, especially those passed by the Senate or emperor, were written out carefully on scrolls, stored in archives, and sometimes published on stone or bronze for public display. Roman contracts were detailed and precise. A sale of land could involve several witnesses, fixed formulas of speech, and careful documentation. Manumission papers freed slaves and outlined their new legal status. Wills were signed before witnesses and often sealed with personal marks or stamps. The act of sealing a document, pressing a ring into soft wax, was itself a legal gesture. It meant identity, intent, and authenticity. Over time, legal writing became an art form. Jurists, legal scholars, wrote commentaries on the laws, analyzing cases, exploring principles, and shaping future interpretations. Their writings formed the core of Roman legal education. Names like Ulpian, Gaius, and Papinian still appear in modern legal study. Their words helped organize the sprawling Roman code into something coherent. One of the most significant developments came under the Emperor Justinian in the 6th century CE, long after the fall of the Western Empire. Justinian ordered a full revision and compilation of Roman law, resulting in the Corpus Juris Civilis, the body of civil law. This massive work preserved centuries of legislation, legal commentary, and imperial edicts. It would go on to influence European law for more than 1,000 years. But even before Justinian, Roman law was already defined by its attention to writing. A man's will could protect his family. A marriage contract could outline a dowry and inheritance. A sealed agreement could move money across provinces. The law didn't just live in the courts. It lived in the daily documents of Roman life. We know this today thanks to what remains: the fragments of papyri, the inscriptions on tombs, the wax tablets preserved in volcanic ash. At Pompeii, archaeologists uncovered a full archive of tablets from a banking firm, revealing loans, interest rates, and property sales. These weren't grand political laws. They were ordinary records, and they show us a society built on legal language. The letters of the law gave Rome its order. They allowed people to plan, to argue, to defend, and to pass on their property and their names. Justice was not only a spectacle, it was a system recorded, copied, filed, and remembered. In the final chapter, we'll step back and look at what survived, how Roman law shaped later civilizations, and why, 2,000 years later, we still feel its influence. Chapter 10. The Legacy of Roman Law. The Roman Empire fell, but its laws did not. Long after the last legions withdrew and the Western Emperor was gone, the legal system of ancient Rome continued to shape the world. What began as bronze tablets in the Forum grew into one of the most influential legal traditions in human history. Roman law provided a framework for contracts, property, citizenship, and justice, principles that outlived the empire that created them. At the heart of Roman legal thinking was the idea of jus civile, the civil law of Roman citizens. But as the empire expanded, a new system developed, jus gentium, the law of nations. It applied to both citizens and non-citizens, and laid the foundation for universal legal standards. This distinction became essential in shaping how Rome governed a diverse, multicultural population. Roman law was practical. It prioritized written agreements, witness testimony, and procedural fairness. It valued precedent. The decisions of past magistrates and judges were studied and followed, and it was adaptable. New laws could be issued by the Senate, the emperor, or through popular assemblies. Over time, a complex and living system emerged, one that could evolve without losing its core. Even after the fall of the Western Roman Empire in the 5th century CE, the Eastern Empire, based in Constantinople, preserved and refined the legal code. In the 6th century, Emperor Justinian ordered the creation of the Corpus Juris Civilis, the body of civil law. It collected centuries of statutes, legal opinions, and case law into one authoritative work. It became the legal foundation of the Byzantine Empire, and centuries later, the basis for law in much of Europe. In the medieval period, Roman law was rediscovered by scholars in Italy. It became the foundation of legal education across the continent. Universities in Bologna, Paris, and Oxford taught Roman legal texts. Judges, lawyers, and rulers studied its structure and clarity. In time, it influenced the development of civil law systems in France, Spain, Germany, and beyond. Even today, echoes of Roman law remain. In modern legal systems, we find its influence in the language of contracts, the structure of courts, and the principles of citizenship and property. The idea that the law should be written, stable, and available to all citizens. That began in Rome. So did the concept that people should be innocent until proven guilty, and that justice should follow a clear process. The legacy of Roman law is not just in books or courtrooms. It lives in the idea that justice should be reasoned, structured, and open to challenge. It reminds us that law is not only about power, but about principle. But the Romans also left us a warning. Law can be twisted. It can be used to control, to silence, or to punish unfairly. It can serve the few while claiming to protect the many. Justice must be defended not only in courts, but in culture and in conscience. From the 12 tables to the legal reforms of emperors, from the wax tablets of Pompeii to the law schools of medieval Europe, the Roman legal tradition has endured. Not because it was perfect, but because it understood something essential, that for a society to last, its laws must be more than commands. They must be commitments. Thank you for listening to this series on justice and power in ancient Rome. If you've enjoyed this documentary and want to support more historically grounded storytelling, we invite you to subscribe and explore our other in-depth episodes.